Welcome to Girl Talk, Divorce Edition. Today I'm joined by Max Emmer, founding family law attorney of Emmer Law, specializing in collaborative divorce, mediated, and amicable family law matters, and Brian Mutter, certified divorce lending professional of Forward Mortgage. I'm Danielle Workman, a private wealth advisor with the Financial Center for Women, empowering women to take control of their financial independence. Today, our topic is a divorce involving a young family with disparate income levels. So let me introduce you to our case. We have Olivia. She's 34 years old and mother of two children. Their ages are 3 and 1. She works part-time in her family's second or third generation business, but she is a bookkeeper for them and she makes about $40,000 a year. She does have a 20% equity share in the family business, and a recent valuation put that value of the business at $22 million. Her husband is actually an engineer. He makes over $400,000 a year, and they own their home. They have a $500,000 mortgage on their home with a 2.85% interest rate. And the house is currently valued a little over $600,000. They're open to options. They're really looking to create continuity for their children. But there are definitely some financial considerations here that we need to take a look at. So the first thing I want to turn to is Max, help us dissect what to do with the fact that we've got some young children. They're going to need care, and how this impacts child and spousal support. I think I forgot to mention that they've been married 9 years. And then there's some interesting concepts here with division of assets because Olivia owns she has an interest in a family business that's not a liquid asset that she can easily settle from. So help me understand what you would advise this couple.
Great. So let's start with child and spouse support. Child support, again, is a statutory formula that has a certain number of inputs. The two biggest factors for child support are the amount of overnights of each parent and the incomes of the parties. So even if this is a 50-50 parenting time case, 40,000 versus 400,000, that is going to be a significant amount of child support just due to the income disparity alone. Spousal support, on the other hand, is not an exact formula. We have a calculator that provides us estimates and guidelines, but similarly but different, spousal support hinges upon the length of the marriage and the income of the parties. With a 9-year marriage, we are probably looking at spousal support for about 3 years or so. A third of the length is a good term. But due to the incomes, there's going to be a specific, a significant amount of spousal support paid here just because of 400,000 versus 40,000. The really interesting part of this is the business ownership. Now, my advice to Olivia would have been, if I talked to her 9 or 10 years ago, have a prenuptial agreement to protect your family business interest.
Yeah.
Now, could she make an argument that passive interest is separate property? Maybe. I don't know how successful that would be. But when we have a non-liquid interest that is in part or in full marital, we usually get the services of a business valuation expert to come up with a number that is worth and then basically negotiate from there. Here, Olivia's family obviously doesn't want to give up any shares or governing or ownership control potentially, but there might be a dollar amount that they say is marital, and then that needs to be accounted for in the global financial settlement. So I think here, coupling young children with a dramatic difference in income, this is going to be a significant child support case, which will go until the youngest child reaches the age of majority or graduates high school. Spousal support, while the number might be significant, the duration likely won't be, because while 9 years might sound like an eternity to some for a marriage, 9 years isn't really a historic marriage where it would be considered fair or equitable for one spouse to support the other on a long-term basis.
Really great information there, Max. I know that one of Olivia's goals was to retain as much continuity for the kids as possible, but they do own a pretty substantial piece of real estate here, and qualifying for a mortgage might be a challenge given Olivia's limited income sources. How might you tackle this, Brian?
Danielle, this is a really good one, and Max's what Max just mentioned, the potential solutions on the support side are very they're potentially useful, but there's also some potential trickiness to them. So we'll get into it. So to your point, if Olivia wants to retain the home, she's going to have a hard time. She won't be able to qualify for a $500,000 mortgage at her current salary of $40K. Now, Max mentioned the likelihood of some, we'll start with child support based on the disparity in income. So this is a situation where if Olivia would need to use the child support, separate from the spousal support, we'll come back to that. We can, Olivia can absolutely qualify for a new mortgage utilizing the child support as part of the qualifying income for the mortgage. However, the mortgage guidelines say that before we can consider that qualifying income to use for the purposes of her new mortgage, we have to document 6 months receipt of that. So it's feasible. She can all day long utilize that child support to help her qualify for a higher mortgage amount, but not until she's received 6 months of child support. So this is a situation where rather than wait until the divorce judgment is entered and finalized, which is when support payments would typically begin, now we have a 6-month runway. What we would do is we would work with Max to effectively have the judge issue child support orders during the settlement of the case, rather than
interim orders to start the clock, if you will.
There we go. Yeah, that's the expression I use. Is in other words, when we have the interim orders, that starts that 6-month countdown sooner, rather than having to wait until the date of the divorce settlement. Now, with respect to the spousal support, Max raises a very good point because, Max, I think you what you mentioned was that, on a 9-year mortgage, spousal support would likely be considered for probably 3 years after the divorce. Right. That is to say that Olivia could expect 3 years of payments, give or take, based on the duration of the marriage. This 3 years, give or take, is very important because not only do we have to show receipt of support payments for 6 months before we can utilize that for the mortgage, those support payments also must continue for a minimum of 36 months after the closing of the mortgage. So in other words, this would be a situation where, if Olivia depended on the spousal support income to qualify, well, then we may have to make some concessions, or we may have to work.
Like we might have to massage the numbers to maybe lengthen the term but lower the amount, because
correct,
that's gonna create a really dicey problem. Which is why working with professionals like us, if you're in a traditionally litigated case, 2 lawyers just going back and forth churning your file, you're gonna have a divorce judgment entered. They're going to drop you, and then you're going to be like, why didn't anyone tell me all of this?
That's exactly it. That's
the planning that we talk about is so critically important for people.
And you just hit it on the head, Max. That's why I love these collaborative cases versus the, kind of traditional litigious divorce, because you hit it on the head. And in a collaborative case, our focus is really on making sure that both clients have eyes wide open for post-divorce life. And it shouldn't be. A divorce is already challenging enough to go through. We want to make sure that these people, on the day the divorce is finalized, that they can sort of feel like they're moving on with their life and not starting from scratch. And what do I do now? And that's what we seek to provide.
Absolutely.
Well, that's all terrific information. One of the things that I'm going to just pick up on that we just began to scratch the surface of is, what to do about an ownership interest in a family business. So our firm has a business intelligence institute. It's a multidisciplinary team of professionals with resources that can help with business valuation, creating buyout strategies. And this couple is what we affectionately call Henrys, high earners, but not rich yet.
Yeah.
And then
I
they're
like that.
one of it's not like they can just they can't just go to the bank and cash in their chips here and take care of the settlement. So we would need to work pretty carefully with our business intelligence team, but also our high net worth team to make sure that we are considering the tax implications, the potential strategy to use equity in the home as a way to offset the business interest if that's an interest of the parties in terms of their settlement decisions, but also make sure that the children are protected should they lose a parent before they're of that age of majority or even through college. And so one of the things that we often will talk about, and I'll point to myself here. I unfortunately became a widow at 40 years old with 3 children, and we owned a family business. So I understand firsthand what can happen with the loss of a parent. That was also a loss of an income and the stress that that can put on the linear financial plan that some people have in mind, where there are no bumps in the road. And a divorce or a premature death are 2 things that can really definitely rock the situation. So there's the opportunity here. Sometimes in divorce cases, there's an order for one party to carry life insurance on a major breadwinner.
Very common.
And
To guarantee support.
And to guarantee the support, but also to provide and bolster a set of savings that could be, and if you use permanent cash value life insurance for college, long-term care, supplemental retirement income, but also obviously if there's an early parent death. So the other thing that I always like to just remind people that are going through any kind of major life change is this is absolutely an opportunity and a requirement to update beneficiaries after a divorce or death of a spouse, to take a look at wills, business interests, trusts, and other legal documents to make sure that the titles and the beneficiaries are all who you intend them to be. We don't want to find out many years down the road that something didn't get updated and a former spouse can make a claim against an asset that would
It's very
probably
messy.
it
And
is.
in my closing letter, I always say, I will give my Rolodex and my research to my clients. I don't shove them down their throat, but it is absolutely a time to either update or get an estate plan, consult with a financial advisor, get a new one, CPA. It's not fun and it doesn't have to be done that day, but this is such a monumental life cycle event that it warrants and requires such actions.
Absolutely.
So I hope you heard today that you really do need to have a lot of planning before a divorce is agreed upon. And if all parties can come to the table in the spirit that they are not out to get the other party, but rather, make it so that their post-divorce life is beneficial to the children and that they both can, have, the adequate money that they need in order to live their lives. Working in a collaborative way with professionals that can help them navigate this, complex world and their finances relative to divorce.
Yeah.
Thank you for joining me today. I
Thank
appreciate
you.
your insights.
Guys, always so good chatting with you. Thanks so much for having us on, Danielle.